Good morning, everyone. Today we are going to discuss the garnishment of severance pay from third parties. Garnishment is an act carried out by a judicial officer at the request of a creditor to target the debtor's assets or his claims against third parties. It is carried out by means of an act notified to the third party and to the debtor, and is concluded with the positive declaration of the third party or with the judicial confirmation of the claim. Garnishment consists of a request to the third party, which is the act of the creditor, and an order to the debtor, which is the act of the judicial officer. The act of garnishment against a third party must contain an indication of the credit on which it is based, the enforceable title and the order for payment, an indication of the items or sums due and the request to the third party not to dispose of them, the declaration of residence or choice of domicile and the certified email address of the creditor, the summons to the debtor to appear, and the warning to the third party of the consequences of failing to appear or of making a false declaration. Decree Law No. 19/2024, converted into Law No. 56/2024, modified the withholding limits of the garnished third party, increasing them according to the amount of the credit claimed. Labor credits are attachable within the limits established by Article 545 of the Code of Civil Procedure, depending on the nature of the credit and the protection of the worker and his family. The employee's creditor can go directly to the employer to obtain payment of the sums due, after notifying the garnishment and withholding the sums within the legal limits, and after obtaining an order of assignment. Amounts due for work may be garnished to the extent of 1/5 for taxes and other credits, or to the extent authorized by the President of the Court for maintenance credits, without exceeding half of the total amount. Severance pay is attachable, whether it is paid by the employer or credited to the employee's bank account, with some differences depending on the date of attachment and the amount exceeding 3 times the social allowance. The collection agent can garnish the amounts due for work in varying amounts from 1/10 to 1/5, depending on the amount, with immediate enforceable notification to the employer. The severance pay does not lose its character as a certain and liquid credit of the employee, even if it is retained by the company, paid to the public treasury at the INPS, or paid into a supplementary pension fund. In all these cases, the severance pay can be seized by the creditor, who will have to wait for the termination of the employment relationship to obtain payment. Finally, it is important to remember that in the event of an attachment of the severance pay, the employer cannot make the declaration provided for in Article 547 of the Civil Procedure Code, nor can it perform the duties of a custodian, but must indicate that the real debtor of the severance pay is the public treasury, to which the preceding creditor must apply. Thank you for your attention and see you in the next video.